lay out what the argument is here and how this case will proceed.
Sure. So what Microsoft had argued was that the emails, because they were stored in Ireland, the U.S. government basically went straight to Microsoft, did an end run around the Irish government and said, give us the emails directly. Microsoft said that the Stored Communications Act, which, as you mentioned, was passed in 1986, doesn't apply in this case because it's an international law. They don't have to give over, material that's stored overseas. Now, the Stored Communications Act doesn't really answer that conclusively, which is why we've gotten to the Supreme Court with this case, because it was passed in 1986. And, that's 20 years before the advent of cloud services and 24 years before Microsoft started selling services in the cloud. So they've argued that since the U.S. government didn't go through the Irish government to request the emails, they don't have to turn them over, and they've refused.
So, Chris, your organization filed a brief supporting Microsoft. Why?
Well, we're worried what the practical result of this is going to be. If we have a world in which any government can reach into any other nation and grab data that's there, not only is that chaos for people's privacy, it also undermines the entire idea of cloud computing, which is to say that you get the same services in the cloud as you would if you kept information on your own servers. And if you've got nations reaching into each other's sovereign borders and grabbing that data, that's manifestly not true. And that's not good for privacy, and it's not good for U.S. cloud computing.
So, Dina, that said, several justices expressed support for the government's side, and there are some real concerns there. Talk to us about how the justices responded to both sides today.
Sure. I think you had the justices pushing back a little bit on what Chris said, fundamentally asking about the technology and saying, well, why does Microsoft have to decide to store this data overseas? And as Chris mentioned, it's part of the whole value proposition of cloud services. And it has to do with latency. Otherwise, if you're in Ireland and your data is stored in the U.S., it slows things down. But there was some pushback on that. I think you had Chief Justice Roberts and Justice Alito pushing back on the idea that this could really impair U.S. law enforcement, and wouldn't this really hamper investigations by U.S. law enforcement? Chief Justice Roberts saying, well, my emails could be stored, halfway across the world just because I ask for it. On the other side, I think you had some of the other justices, Justice Sotomayor and Justice Ginsburg, pushing back on the ways in which the law is just outdated and saying, Justice Sotomayor asking, should we not just wait for Congress to update this law? And there has been a bipartisan bill, introduced called the Cloud Act that would address many of these issues. And it's one that the technology companies and the government seem to agree on. Now, the challenge is, A, the Supreme Court doesn't usually wait for that sort of thing when they have a case before it, and B, the bill may not get passed. It's not the first one of its kind that's been introduced. The other ones haven't gone anywhere.